Okay, we should be recording.
Like my little old lady chick, that's my mom.
Hello, everyone.
Hello.
Hi, Scott. Hi, Scott.
Hello.
We received your question about derivative works. Is it correct that you have a license to somebody else's copyright?
Yeah, yes, thank you for reviewing my question. If you guys need more context or more information, I was trying to get that into you guys quickly. So, but yeah, no, we're working on an agreement right now where we would actually be, we're on the licensee side of things, so to speak.
Right. So you're bringing something in.
Correct.
And the agreement says that you have the right to make derivative works with it.
Correct.
Is that right?
Yeah, we're
Okay.
authorized to prepare derivative works. That's one of the bundles of rights that we're authorized, that are granted to us.
And so the question is, will you own the copyright on those derivative works?
I think that's a definitely initial question that we want confirmation on. My understanding is that we would, because of the authorization to prepare in the original grant license.
Mm-hmm.
But also is if that's the case, right? Should we explicitly put that in the agreement that we are in fact the owners of such derivative work? And for Eric, who's my colleague, I'll send the question in the chat. I don't think you were.
I don't know, Brian, do you want to weigh in that? I mean, I think that it makes sense to be clear about it so that you won't have problems in the future. So I think that's always a good idea. The other thing,
yeah, I mean, it's kind of tough to handle it on the fly, and I'll put the caveat out there that I'm wearing my Syracuse University Innovation Law Center hat and not my Von Schenicken King hat, and anything I say here is my own and not a reflection on Von Schenicken King. Yeah, I mean, so I'm looking at the email, and the first thing that jumps off to me is to make sure we've got a good definition of derivative work, and make sure that whatever it is you're envisioning, you want to have exclusive rights to, falls under that definition of derivative work, explicitly or expressly, rather. And then trying to read the first. Sorry, I just
No,
got
don't take your time.
jumped on.
It kind of came in about 10 minutes ago, so it's all right. You're trying to
yeah, and
we can have we're just trying to have, we had a lot of conversation about this issue, derivative works, and how that would reflect with the original creator, et cetera, right? And like, if there's new versions of the original document, for instance, how does that all play out? These are things that we've discussed, right?
Can I ask what it
Yes.
is that you're licensing and whether the license agreement talks about?
Can you say that again?
I was wondering if you can say what it is that you're licensing and what the licensing agreement says about who owns the derivative work, or is that what you're talking about you're negotiating currently?
Yeah, correct. Let's just say we're negotiating currently these terms.
Okay.
And it's a content. There are modules of, that can be for instructional purposes, right? For instance.
Okay.
And there's a chance that these modules or classes will be, modified and might fall in the definition of a derivative work, right? And since we're authorized to do so, right now it's not explicitly, actually, it's not, we were contemplating whether to institute that we are in fact the owners of the derivative work.
Yeah.
Or under copyright law, from your understanding that it already is implied based on the grant of rights that we are the automatic owners of the derivative work, just based on how copyright law flows, right? in your understanding.
Yeah. Are you licensing it into Binghamton/SUNY from a non-SUNY institution? Or is the SUNY Board of Advisors, the trustees' policies on intellectual property and copyright at all relevant?
Yeah, good question. Scott, I'm gonna have to go from guy to side for you on that, I think.
No, I mean, yeah, let's suspend the policy part because
Yeah.
that's our operating constraint. But in essence, in broad strokes, right? It's micro credentials is all the rage. So wherever these creators are, we're gonna. I mean, we think we're commissioning the work. We have our own opinion about it. We're commissioning the work. We're paying them, but we should actually own it. But that's a different question. We're not say. So we're saying, okay, creator, you have this content. Great. We'd like to license it in and be able to deliver it in these courses.
And the licensing in entity is not a SUNY entity.
That's us. We're licensing in.
Yeah, for our purposes, it's not a SUNY entity. Let's just say
Oh,
that.
creator is
Hypothetical.
not SUNY. It's
Yeah.
just a person, Joe Blow.
Yeah, Joe Blow, right? Yeah.
Okay.
John
Yeah,
Smith.
so you can't work this is a work for hire situation into the language of the agreement, which therefore then gives you
Right.
rights to that copyright. I mean, a derivative work typically, the synonym is adaptive work, right? So typically you got a screenwriter that has a movie, and then you take the screenplay and adapt it into the movie, right? And then you own the copyright on the actual motion picture, not the screenplay or licensing the screenplay. So here you've got, an educator who's got a written material, and then you're actually going to be recording, the lecture, or is it you're taking the lecture and modifying it or adding to it, and
It's
then,
probably more of the latter, I'd say.
okay.
Right. So think about it. You could say this creator is potentially a professor, but it doesn't have to be. It could be someone else, John Smith.
Right.
But say in the former, because that's more realistic. Then they leave the university here, it goes somewhere else. So we want to still be able to deliver that material, and maybe some new other professor will modify it a little bit and deliver it. We want the right, we want to own the derivative work so we can do that.
Yeah, but you're paying them, right, for the initial
Yeah.
lecture.
Yes,
I mean, so to me, it's like, oh,
We
know.
we know.
We
own this.
know, we agree. It's just a funky situation. We just want to make sure that our understanding is correct just on this issue, so that we can apply it to our set of facts that we're dealing with at the university level, right?
I mean, I would.
On the same page, or the correct page, so that when we do try to sign and put this agreement in place, that we have our, save our asses there a little bit. If you understand what I mean.
I mean, I think you want to take a belt and suspenders approach, right? One is, this is a work for hire situation. We own this material, and you will assign any copyright you may have in it to us. And then, secondly, have a derivative works clause in there to say, we can adapt and use this, as we see fit. And, these will become derivative works, and you have no ownership right into the copyrights of, the performed, the modified, whatever we're going to call it, the modified lecture series or what have you.
So you suggest, just clarifying the work for hire element, right, as an addition.
Yeah, I mean, if you're paying them, I mean, you're paying them for that copyright, right? Which is the exact words on the page, and we're going to adapt that. Then unless they're going to collaborate in the adaption, then I'm not sure they technically have any rights to that.
Okay, great. That's very helpful.
Right.
Thank you.
Yeah.
Thank you.
So let's say there's a boot camp, an in-person course that comes with a certification. My background's healthcare, so I'll say CME, continuing medical education credits. But now Binghamton wants to do it online because they're into these micro certifications. So now it's got to be adapted from the live venue to virtual. That's where the work for hire comes in, but you want to maintain the certification part. So, you know, that's a scenario where, yes, you're doing work for hire, but you're kind of licensing in something that is also being adapted so you can maintain the certification process. Am I close in that scenario?
Yeah, I actually think that in the grant of rights, we're allowed to already do live and virtual.
Okay.
Because they actually have made, I believe, if my understanding, they've made both operable, right? The original creator, they've actually made a live version, and they've also made a now Zoom or virtual version, right? Where they can do it online and actually self-paced, right? So I think that's more the key here, and they like the self-paced model. That's speaking from our end, right? We like to say it's self-paced. So I think that might be the way we move forward. And we do have grant of rights to use live or online too. I think that was important. And I actually made that change because we need to have both instances. There's also a thing, I don't know if you've ever heard of the TEACH Act, TEACH, in copyright law that talks about that actually online, if it's teaching materials under copyright law. I recommend it. It's an acronym. You learn about online versus in live instruction. There's some different key differences that you might need to actually put that explicitly in your agreement that you're authorized, or you could run into some trouble. But that's just something I ran into when I was investigating this. But yeah, I think that makes sense. I think Scott will have to maybe think about the work for hire. I don't know if we want to go that far. We've talked about that quite a bit too. It's just interesting circumstances that we're dealing with, frankly. It's not typically how we operate, I'd say, but it's just something that came to across my desk, and we're dealing with it as we can. And we just wanted to verify our understanding. I think what you've said, Brian and David and everybody, Molly, I appreciate it. Your insight and feedback on that topic.
I've just been looking up the derivative, the SUNY Board of Trustees policy on copyright. So if that might be somewhat helpful in terms of if it's, and you're probably fully familiar with this, but if it's somebody from Binghamton, then, then
The scope of employment comes in, right? And
Right.
yeah, because it says they retain the rights to copyright, but if they're employed or directed within the scope of their employment to
Right.
produce something specific, then the university has rights to it. So, I don't know.
yeah, we actually are outside the bound. Unfortunately, we're outside the bounds of the policy. We have to,
Okay,
I don't want to know if we're going to go too far into that area, but it's just, we just wanted some clarifications so we're prepared.
We're doing a workaround. In essence,
Yeah.
we're doing a workaround, and we're getting, so that we can own the derivative work, end of story. So we don't agree with the
Right.
front end part,
Yeah.
but that's the hand we were dealt. So now we're going to get the rights to the derivative work.
But I mean,
We want to have derivative work access, right? That we own it, right? I think that's where we want to have it. And I think it's under the copyright law as it is, and then it's another good question for you guys maybe is how would you recommend, maybe this is more of a business more than legal decision or conversation, but splitting royalties. I mean, I know we don't have to count to the other creator necessarily for the derivative work, but there's sharing mechanisms that we might have to be instituted contractually, right? Not under copyright law, but just contractually, we might have to make some proportional splits.
well,
So
yeah,
I don't know what you felt would be a too aggressive split, or you think 50-50 makes sense, or should you do case by case analysis of is the derivative work, a way better version or way different, right?
trying to figure out the value.
Right.
There's a whole, yeah.
yeah. I mean, you
That's
got
what we have internally. I just didn't know. I just thought I'd broach it with you guys just to hear your thoughts. I think.
Yeah, I mean, you gotta keep in mind that on the derivative work, I mean, the original copyright owner is gonna have, or the author is gonna have the right to that original work. You're just getting, the modification, the additions, that's what you guys are getting ownership of. So, depending on how, I'm sure I mean, I don't know what the topic is, and it may get stale after 6 months, or it may get stale after, 5 years. I don't know, but that's something. You might have a sliding scale or something, because
Right.
after a year from now, you may have completely, adapted what the original work was. So that's a whole new work of authorship, right? So,
Correct. Yeah, correct. I think that makes it a sliding scale. And we've talked about that when, it's become so far removed. It might be original. It's probably original, right?
right,
So,
right.
We don't know where to draw the line, where it becomes derivative that we no longer, would need to count to the original, that it decayed or so far removed. That's what we're also struggling with a little bit. I mean, you can do the math, but where's the line?
I mean, time,
I mean, I suppose you could do
Time-wise?
that contractually, right? Like you have a, 2-year agreement with an option to renew, and then that way, you guys can build in some, some experience with this, and like how, how much adaptation you really have had to the original, script or the original lecture, and then you get automatic, if it's like, wow, we really need this. This is something that we, are going to continue to teach, and then you renew your option each year. But then at some point, you're going to come into a situation where you need to make that call, like, where have I gone in the scale of derivative to now I've got an original work where I don't need to pay this person anymore. So, that's one way contractually you can build in, that kind of like learning curve, if you will, with, options to renew and keep the main contract, tight to a year or 2 years, whatever, maybe 3 years, I don't know. And then build in some options, that you get to exercise, not them.
yeah, no, that's pretty good. I think something we have to consider, I think. Because we might get a feel for how, like you said, we might get a feel after 2 years how this might actually operate in practice and how much.
So we try to think
happen.
ahead. We try to think ahead, like this case, what are the permutations? It could be the original work is also delivered along with the derivative work. It could be another separate original work plus this first original work, like, right? And so how do you apportion value? Yeah, and upfront, a priori, how do you know? So that's your good suggestion you make to see how it goes in practice.
Because
Molly,
just to add on to that real quick, sorry, David, we're anticipating, and we've talked to the instructor, the people that are facilitating these micro-credential courses, and they believe that there could be one course could have several different modules, right? And within those, people are creating 1 or 2 modules within the larger picture here, right? So we think there could be original, and that one module might be very important to the whole overarching class, right? So we've anticipated or contemplated that, that they need to be accounted for, right? They can combine the original work, but also have another module from a different party that they've added in, right? And they might need to. So that's something that we've thought about quite a bit here of all the different scenarios. We're not going to capture them all, but we just want to make sure we have ways to apportion the revenues to everybody that's involved.
yeah. So I was just going to weigh in on the contractual aspect. So again, sort of taking the, defining the original work based on the number of hours or the number of exercises or, what the passing grade is for the certification. And then your derivative work, you say in the statement of work, here's what we're expecting. And that's the work for hire aspect. As far as contractual, and, I've done it where, and again, this is medical devices, we've had the royalty split after we recoup our investment, let's say in getting FDA clearance or something like that. So upfront, it could be a 70-30 split on the royalty, again, until we recoup our initial investment, and then it goes to 50-50 or whatever. So you can have milestones in there after, you know, you've recouped your initial investment in creating the derivative. The question is, and I think Molly, you were going to weigh in, you know, how do you define the derivative work? And once you define it, if you add other modules into that certification process, then they don't have rights to the royalty for that. So let's say there are 3 courses in one overall certification. And by the way, I've taken courses at UVA at the Darden School, and you get a certification for each module, but it rolls up into one big certification. So, you know, again, you just specify the derivative work so that if there's income on something outside of that derivative work, another module that somebody else authors, they can't come back and claim, oh, I get royalties to that too, because it's all part of the same program. Does that make sense?
Yes.
It can make sense. Yeah. It could also be though that there's the one centerpiece that's the most important, probably maybe the original work, and then it will take conversation, like, yeah, and how to, so that people, I don't think it's very easy to do a priori. That's just the thing of it, like how you apportion value and get everyone on the same page. That's going to be tough. I know what you're saying. You can try to isolate it by the individual module if possible, to the extent possible. I get that.
I have every confidence in you, Scott.
I'm not that good at math. I don't think. You need a supercomputer.
I mean, usually like with trying to value something, you know, you look at comparables and you look at the, you know, if you can find other similar courses and what people pay for them, that would be really helpful. And I love what Brian said about, you know, reserving the right to renegotiate after the milestones, like Dave said. So building stuff like that in allows you to wait and see what progresses.
Right.
Eric, do you have a question, or Scott? Are you guys joining us just for the conversation, which is great?
I love just listening. So, Molly.
This reminds me a little bit, there's another question that comes up, and that we get a lot, is that with startups, they can't afford to talk with an attorney, although I think Brian would say that most attorneys are happy to figure out a way to do an initial consult without charging, just to try and figure out if they can be helpful. But we got questions this week about user rights agreements for software platforms that people are developing. And they're wondering, hey, can I just go to Zoom or to, what is it? Not Zoom. You know, that online legal service.
LegalZoom.
LegalZoom.
You would have-
LegalZoom. Oh, it is. Okay, thanks. And so I wondered, kind of putting you on the spot, Brian, but can you discuss some of the downsides to doing that? I mean, we as lawyers are very risk adverse. So we always want people to consider what can go wrong if they do that. And then if they can live with those consequences, I guess that's what they would do.
Well, I mean, I guess my just general comment is the old adage, you get what you pay for, right? So if you go on to LegalZoom and you pull off a user agreement and, you know, those, you know, I don't know. Sometimes those work, you know, sometimes if I'm forming an LLC, maybe, but you know, when you're talking about end user agreements and, you know, there's lots of nuances that go into that. So it's, my recommendation is, you know, talk to an attorney about, for, you know, I don't know. I mean, I don't know enough about how that thing works. Maybe they have attorneys they talk to. I don't know, but yeah, that's, you get what you pay for. So I'll leave it at that.
I'm sorry, I'm on mute. Okay, fair enough. Other questions we received were about patent marking and what has to happen with regard to that to preserve your patent rights.
Yeah, and then I thought one of the concerns was they had the actual device was, or whatever they're inventing, the technology was very small and they're worried about getting a marking on the actual product. And we actually covered that, what, a week or two ago now in our class, where typically, in our situation, we had a medical device, implantable medical devices, and we had a component in those IMDs, and we couldn't etch the patent numbers on the actual component. So how we satisfied the patent marking requirement, which provides, and it's a statutory obligation of a patent owner, is to provide the number of the patents that a number of the patent that is used, covered by this technology. You need to put the public on notice of what that is. And typically how that's done is, under a purchase order or something like that, and the paper documentation that goes along with the sale of your product, you list the series of patents that are covered or that are used to cover that technology. And that's how you get around, etching super small numbers into the, side of a chip or something like that.
Yeah, well, Jalen, we put a lot of the numbers in the instruction booklets. They went along, and some of the products had many patents associated, and you could list them on the instruction booklet.
I've seen some online too. Some companies will list their patents right on their website.
Mm-hmm. But it is an issue in patent litigation. The accused infringer will argue that, because that's when your damages begin to run, when there's notice has been adequately provided. So that is an argument that will come up in litigation, that we weren't on notice of the patent, and your damages don't get to run until you, as the patent owner, can show that you satisfied that statutory requirement.
And it doesn't count that it's published, at the USPTO. They have to associate it right with the product.
Yeah, there's a separate patent marking requirement in the statute. So
Yeah.
it's not enough that it's in the official gazette or has been published. The actual patent has been granted. That's not enough.
Yeah. Well, Jalen, when we were in the litigation with Olympus, we weren't very good about that, and we put the patent numbers much later than when we had the product come out of the market, which hurt us a little, but we still negotiated the settlement.
Another question, this all ran together, sorry, so it's hard to just put it. When is the best time to file a trademark registration? I talked to a couple of people in the last few weeks that know the trademark they want. They've looked it up on tests. They don't see anybody's using it, but they're not ready to, they're not in business yet. They're starting to pull everything together. And so anybody want to comment on that?
I mean, I think if you have the money, the thing to do is it's called an intent to use application, which, technically your trademark is not, you're not eligible to register the trademark till you can show actual use. But you can file what's called an intent to use application that at least gets you priority. You're in the trademark office, and your application will get prosecuted, and then before it will be placed on the principal register, you need to file what's called a statement of use, which, we've actually put this product into commerce and we're using this mark in commerce. In fact, we just had a client where, it took us 6 months or so for them to finally, they're like, well, we've shown it to we've shown a model to a client. I'm like, well, has there been a sale? No. I'm like, well, it's still an experimental use. Like, once you actually ship that thing out, give me that date, and then I'll go in and file the statement of use that it's actually in use, and now we can move forward with registration on the principal register. So
You
but
need,
that's at least a way to secure your rights in that mark and not let somebody else beat you to the punch.
Brian, do you need interstate commerce on that?
For federal registration, yeah.
You do.
You know what I've seen a lot of people do is they put up, they make a website and they have their name and they have about us and they put something about their team and maybe something about their product and it says contact us. But I don't think that's actually doing business, right? I mean, they just want to try and.
Yeah, it's
that
mere
is-
it's mere advertising. I mean, it's that's kind of what this client was getting a little bit frustrated. They're like, come on, we've got these contracts. I'm like, well, you haven't shipped it out the door yet, so it's not officially in commerce yet. And then you've got to file an affidavit with the office and say that it's so that the last thing you want to do is mess up your registration by not fulfilling a duty of candor to the office by filing a false affidavit.
Right. We had one guy who had been selling a certain kind of seafood on Long Island for years and years. And he had this very intricate mark and really liked it, but he'd never sold anything outside of, he never shipped anything outside of New York. So his question was about common law trademark, which, he can establish, but like to Dom's point about the federal register, he'd have to find somebody to ship it to in Connecticut or New Jersey or something, right?
Yeah, I mean, you can get common law rights just by using it in commerce, but you're not going to get nationwide coverage like you would if you file it with the trademark office.
So does in-commerce equate to a sale or is the standard offer for sale?
It's got to be an actual sale.
Um,
A fair market value sale price or $1 sale is makes it.
Yeah. Oh.
Well, you actually end up,
I mean, you can you can file whatever you want with the trademark office. It's just if you're going to get in a fight over the mark later on in litigation, trust me, that's going to be uncovered, and they'll challenge whether or not you had an actual use or not, and whether or not the mark should have registered in the first place. So
try to sell it for real money, Scott. Not $1.
sell it for $1.50. $1.50.
Well, I was going to say, I don't know what you're buying for $1.50. Worth it.
well, it is interesting because you have to wonder, we tried to trademark, and I think actually we do still have a mark on Lab to Market. And, but every 3 years, I think you have to show that you've used it and where you've used it. And so it's an interesting process, that's for sure. Okay, what's the best business entity for high growth potential tech startups? I think this gets into New York versus Delaware and whether you should start off with an LLC or a C Corp or S Corp. Brian, you're on the hot seat today.
Yeah. Well, I mean, I guess it depends, right? I mean, it's easier to raise money if you're an actual corporation because, investors will want a seat on the board or they're going to want equity in the company. It's much easier to issue stock and equity in the company if you're an actual corporation, as opposed to an LLC. But starting out, if you're just two inventors, may not have the bandwidth to comply with all of the, if you're in New York, the New York State corporate laws and all the requirements for board meetings and minutes and this, that, and the other thing. And so an LLC might be, the ease of doing business might be the LLC route. You can always convert it into a corporation when you need to. So it really depends on the situation and what, where the entity is in the life cycle. From startup to gazillionaire.
Dave, you're noting,
Yeah, I was just going to weigh in based on my experience. So once you get past the seed stage and the convertible debt stage, if anybody's investing for equity, then they like to have a C Corp for all the reasons Brian just mentioned. Seats on the board, filing requirements, all those things. So as you scale, it's much more important to be a C Corp if you're going to get outside money. If you're bootstrapping I'll say a lifestyle business, it's much less important.
yeah, because there's different classes of stock, right, that can't be issued with an LLC, but can with the C Corp.
Correct. Yep.
Dom, do you want to talk about, we've seen this issue come up a lot where people have something that's sort of in the medical device space, but they are convinced that they don't need to deal with the FDA because it's a wellness product.
Right. Yeah, I can talk about that. Yeah, people, if it's a medical product, and typically simple medical products can be just class 1, just Band-Aids and Q-tips, but they are medical, but they're not, they don't treat diseases or diagnose diseases or anything like that that would be, more stringent. So, but they still need to have GMPs or, they have to abide by a good medical practice situations in their factory, wherever they're making it. And also standard controls, or just normal general controls. So they still would have to do that. And they don't have to apply to the FDA. They just have to notify the FDA that they're selling this. So they don't have to get, it's not really approval, but they don't have to go that route that some people call approval. They just have to give notification. So that they do have an FDA. I mean, still good manufacturing practices. There's things that they need to do. And if some reason that FDA knocks on your door, you have to show them that you're doing, going through those practices.
Can you give an example? Oh, sorry.
Go ahead, Scott.
Could you give an example maybe from the Welsh Allen or Rom Hill, like a medical bed or hospital bed? When would it become a class 1 versus just a bed? A bed is a residential bed, or like a hospital bed. Does that ever become a class 1?
Well, if you can say it does any diagnosis, or if you have instruments associated with it that might help diagnose diseases, then it would be.
So if it was censored for pressure spots or something like that, it would be a class 1?
Right. Otherwise, it wouldn't be. But you still have to go through and make sure you build it correctly, and you take the records and keep track of them, because there could be issues with that. The bed could fall down and hurt someone. And someone, FDA is going to be knocking on your door and say, okay, how did you build this? What are the controls they used? And so it still could hurt someone, even though it isn't for diagnosis or for curing or mitigation or treatment of diseases.
Do you think some beds, like you have to raise the feet up so that they're elevated? Or, I mean, in some ways, does it help with treatment? Also with traction? Do they still have traction anymore?
Yeah,
I don't
I left Welch Ellen before it was into beds. So they don't call them beds. They call them surfaces. They don't make beds, they make surfaces. So that's an interesting.
No, Dave, when you're talking about VCs, oh, were you gonna say, well, I was just gonna say, when you talk about VCs, can you talk a little bit about the like, we try to provide market research to our clients when we do projects. And I was wondering, I've just always wondered, like, do VCs actually ask about, what do they want to know about the market and those, the statistics and figures that we try and provide people?
Yeah, so in our due diligence reports that are, part IP landscape, part freedom to operate, some regulatory, like you were and Dom were just talking about, we also cover the market. So, and the competitive landscape. So what people want to know, the funders want to know is, do you know the market? Do you have any traction? Because they really don't care about the total available market. They do care about the service addressable market. And more than anything, they care about, do you have context? Do you have traction in the market so you can get from where you are to that service addressable market? It's always much better to build your business plan from the bottom up rather than the top down. So top down would be, hey, I'm going to get 10% of $1 billion market. Well, that's a great theory, but how are you going to get there? So the bottom up method, where you say, hey, I've done these pilot studies and these early customers have paid for my product, and here's how I'm going to get more of them, is much more credible. So we can provide some of that at the Innovation Law Center, but after our due diligence report, any entrepreneur, any startup would want to start to get traction in the market. And that's what gives them credibility as they go from seed to angel to, A rounds where the VCs get involved. Does that answer your question? Okay.
Yes, thanks.
Yeah, we've covered a lot of ground this week. This is great.
I don't know if anybody else has anything, but what I've just been learning about from this one conference are standard essential patents, which I haven't really been that familiar with. But I guess there's a lot of debate about, when you have a patent that's essential to an industry, then there seems to be some way that you can be compelled to license it, that you can't say you won't license it. It's more just what the terms will be. I don't have a lot more to say about those. It's just, I hadn't really been that aware of them. So I didn't know if anybody else had any information they wanted to share about them.
I've also seen some reports lately, it's fraught with potential litigation as well, or just for compulsory licensing. There's also, when they looked, I think some studies have been done where they try to say, is it truly a standard essential patent or not? Because sometimes that confers benefits on the holder and they just claim that category so they can trade it for something, but it's, so they're subject to some abuse. I feel like it's not, I think probably the courts will have to help stabilize how they're used and classified.
Yeah, it's not clear how it gets determined that something is a standard essential, although, like you say, I mean, it always comes with a new kind of technology, so there is generally litigation around that.
I could expand a little if you're interested. We're involved with this patent pool. There's an initiative amongst 15 universities, and it's in the same ballpark, right? Because we had to go to the Department of Justice Antitrust Division to get a clearance. It's a clearance where they say, well, we wouldn't be compelled, given what we hear, what you've said, this is how it works. We wouldn't be compelled to like investigate this at this time. That's kind of their way of saying, yeah, it looks okay. And because we had to, you know, sort of document, spell out that, yes, we would, we're trying to stay away from standard essential patents actually, but if it were to be that some became that or whatever, you know, that we would, you know, we would in that spirit or whatever of making them available, we would, you know, we wouldn't like force them to license all the other patents just so they could get to that one or two, right? So there, it definitely is out there. It's definitely part of the superstructure here.
How did the SEC, were you compelled to go to them or they came to you?
Department of Justice, we went to them. We
Okay.
went to them. There's a,
Wow.
I guess, more or less a format, and you have to explain, you know, the framework you would be providing licenses under and why that's not anti-competitive, make the case.
Okay. And Scott, it looks like you gave us a good resource on these maybe?
It just gives you a little background on some of the debates on fair and reasonable terms that they usually are under on these SEPs. And to Scott's point on about, I think there's a patent, another licensing program that has these SEPs, Scott, or am I wrong about that?
I don't remember whose that is, yeah.
Is there a patent pool with some standard SEP patents that were?
Well, yeah, there are other patent pools with those, not our university one.
Not ours, but yeah, that's how another way of, like you said, article outlines how much they get a great negotiating position if you're the owner of that patent, right? But that's the debate with these FRAND agreements, which typically are licensed.
I mean, I don't know if in David and Dom's experience, you know, with Welsh Allen, where they, you know, whether it's just that or it's cross licensing is sort of a cousin, I guess, right? I don't know if they experienced that.
I have no experience in that.
Yeah, I think they're set by the organizations that standardize, you know, like the CE or other type, like electrical type things, only for things with energy.
IEEE or, yeah.
Yeah, I'm not quite sure of your exact question, Scott, but the example that I was thinking of from our Welsh Allen days was there was a communication protocol. So it was a software that sort of promoted interoperability. So it was essentially middleware, but really anybody tying into an EHR would have to go through a similar process. And so we did sort of write a few, hey, you might be interested in taking a look at our patent and making sure you don't infringe. So it was sort of like a freedom to operate warning. And we got some people to answer our phone call after that. So that was one example that came to mind with, you know, a communication protocol. That was, I wouldn't say it was an industry standard, but it was kind of like, tell us how you don't infringe. Otherwise, we should talk about licensing. And you know, my letter was the last nice guy they were going to talk to, because after that, it was billable hours. So
Right.
I can see Dom smiling. You've written a few of those letters in your Welsh Allen days too, I'm sure.
Yeah. Yeah.
Well, does anybody have anything else they'd like to talk about or ask or?
I just thought there was a question earlier from an email, not today, but sent in something about, you know, filing a patent application overseas because that's where they thought they were going to do business or primary market was. you know,
Oh,
and
whether
then,
they should choose PCT or USPTO if they think they're going overseas. Right, okay.
well, yeah, I mean, I can't, obviously, there's a myriad of factors that go into that, but the threshold question is if they're a US company and they want to file in an overseas patent office first, they need to get a license from the US Patent Office in order to do that. If you're a US company, you need to file here first in order to do that. So if you're not going to do that, you need to seek a license from the patent office in order to do that. So
Oh,
it's
If
called a
you
foreign
decide-
filing license.
so you can't just choose USPTO or PCT if you're a US company. You have to go to the USPTO, get a license first, and then you can start with PCT? Is that what you're
That's
saying?
it's basically if you plan to file a foreign patent application before filing a US application, and you're not going to seek a US patent, then you need to petition the PTO for what's called a foreign filing license.
Didn't know that.
Yeah, I didn't know that either. I've seen a bunch of articles lately about advantages to doing the PCT first, because some people argue you end up with more time but I guess that would be if you really think you're going to have an overseas market. You'd have to be pretty sure of that.
So just to ask for clarification, Brian, so to Molly's point, can you go straight? Can you make an initial filing as a PCT without, say, a provisional US or even a non-provisional US? Can you go, is there such a way to do that, straight to PCT?
Yeah, my understanding is you can, right, Brian? You can, because one of the PCT countries is the US.
Right.
So,
Yeah. I'd have to take a closer, I mean, it might be technology specific. I don't know. I'll have to take a deeper dive into that, but yeah, you can look up foreign filing license, but that's kind of where I thought that initial question was going, so.
but I believe we worked with some companies that did go right to the PCT. And then US was one of the countries they filed when they have to decide who to file.
Right.
It's the US and Germany, and then it goes that route because they wanted to do foreign filings. And as Molly said, it does give you a little more time, but they do examine the PCT process. You're like a provisional in this country, they don't look at the provisional.
Right.
But PCT, they do examine your application. So it is searched and basically approved, I believe. So, but
There does seem to be a trend, not in our practice, our small practice of it, but that people there's more discussion about not going PCT, just going directly, say, like a counterpart, say in Japan, right? Don't go do a US filing and a counterpart in Japan, but don't, I see that a little bit more now somehow trending.
Yeah. It might be, sort of along with the criticism just on those blogs that you see about, is the US becoming not patent friendly? But you see, over the last number of years, I've noticed it kind of goes like a pendulum about what people think about the USPTO, probably based on bad experiences or not. But. All right. Well, I think we should wrap up.
All right.
We look forward to seeing you maybe again next month.